My name is Christian Kim, and like Eunice said, I'm a criminal defense attorney, and I'm here to talk about just a couple things. One, like what it is to be a criminal defense attorney, and I'll just briefly touch upon that, and then the rest of the time I'll talk about what a juvenile criminal defense or juvenile court system is like when you're in charge of the crime, and also what are some of the possible things that can happen if you're unfortunate enough to be accused of a crime in juvenile courts, as well as what you guys should be doing. So just a brief introduction. I was told to keep this very brief, and that's like if you're telling an attorney to keep it brief, that's like telling a kid not to eat ice cream. So I'll try not to be too long. Like we have, especially trial attorneys, we have this tendency or instinct to the longer we talk, it seems like we feel like it's better for our clients, but a lot of times it's not true. The opposite is actually true. Keeping it more brief and concise sometimes does the trick better. So I just try to keep it as brief as possible. Basically, I graduated from Cal State Long Beach with a poli-sci degree, an emphasis in international relations. And that's a good thing about going to law school. You can basically major in anything you want. And it's not like pre-med, you have to go into some type of science background. You can major in philosophy, you can major in mathematics. But if you decided you wanted to go to law school, they'll take you as long as you meet the requirements. Then I went to Loyola Law School. Give me 1 second. I can put this on this other side here. I went to Loyola Law School and, basically went 3 years there. I went to Loyola Law School with the intention of being a DA because I always liked the idea of being in court. I always liked the idea of fighting for justice. In some points of my life, I wanted to be a cop, but I thought I'd be better served as a DA. So I clerked at the DA's office all 3 years that I was there, and basically kind of put all my eggs in one basket. And fortunately, it worked out for me because I was hired at the Orange County DA's office as a deputy prosecutor for many years. Basically, deputy DA is a prosecutor. We prosecute misdemeanors and felonies. So anytime there's a misdemeanor or a felony committed in Orange County, we are responsible for prosecuting it, or not we, they are now. I don't know if any of you guys will ever, thought about going to law school or wanting to be a trial attorney, especially a trial attorney. Being a DA or a public defender, that would be a very good idea, at least initially, to get your feet wet and basically learn to do trials and be in court. Basically, they just kind of throw you in there. It's like, learning to swim by getting yourself thrown into a pool. And they basically, day one, they just give you a file and say, hey, go try this case. And that's how you learn. So I was there for like almost 8 years. And I did a bunch of trials and a bunch of cases. So it would be a great experience. If you ever wanted to be a defense attorney or even wanted to be just a trial attorney, even if it's like civil stuff, that would be a great place to get your feet wet. Ultimately, I was assigned to a special assignments unit. Basically, that's a unit where they prosecute media sensitive or cases that might attract media attention, or we prosecute cases where it involves defendants that are in positions of trust, like police officers or politicians, or even celebrities. One of the cases that I remember the most in our unit was when we prosecuted Snoop Dogg, when he according to him, inadvertently brought in some type of weapon into Orange County John Wayne Airport, and he got prosecuted for that. So we were prosecuting Snoop Dogg for a little bit. So that was kind of an interesting case. After I graduated from after I was at the DA's office for a while, then I went into private practice and basically specialized in criminal defense. And basically, criminal defense is the opposite of being a prosecutor. You basically are representing the people that are charged with crimes. If they are, charged and arrested, whatever, they have to go to court. They need an attorney to represent them in court. So that's what I'm doing now. Let's see here. Oh, why criminal defense attorney? Why did I quit the DA's office to be a criminal defense attorney? One, and this only pertains, my experience only pertains to being in private practice. One is being my own boss. Basically, if, I'm self-employed, so I can basically set my own hours. I can be, very flexible in when I go to the office or when I'm working. So that's a great thing, regardless of how much money you make. If you can be your own boss and make a living at it, I think that's a good way to make a living. Let's see here. And I found, and I went to the DA's office wanted to be a prosecutor because I thought that would be helping a lot of people. But I found throughout the years that being on the other side as a defense attorney is actually, you get to help more people because you get to meet them and find out things about them, meet their families, see them as people, and figure out why they're in the position they're in right now, what went wrong, or what poor decisions they made, and try to help them out of it. So it became more, these cases became more human and more, I was getting more emotionally involved in it because like I was getting to meet them and see them as people. So in that aspect, that was pretty good. And I became convinced that I was doing more justice on the defense side than as a prosecutor. Frankly, and you can, have the possibility of making more money. I mean, that's always good, right? As a, in private practice, it's basically a business. So the more harder you work, better you get, the more experience you get, you have the opportunity. Not that I'm saying that you're always going to be like that, but if there is an opportunity to have better in a better financial situation where you can make more money if you work hard. So that's basically why I became a criminal defense attorney. Now this is for private practice. If you are if you work in the public defender's office, that's the other thing. If you work for the public defender's office, let me go back here. You work for the county, so you get a paycheck, but everything else is the same in terms of being able to help more people and doing cases that are worthwhile. But it's a little different because you're not in a business for yourself. But so this only applies to being in private practice. So let me get through here. So and this is just, I'm sure you know most of this stuff is you got to go through 4 years of college and then 3 years of law school. You make sure you take the LSAT, basically just like that's the standardized test that all you have to take in order to go to law school. And it's basically like the SATs or the ACTs. So you take it after you graduate or while you're in college to basically get a score, and your GPA and your score and everything else will determine what type of law school you go to. Then you go to 3 years of law school. And for anybody that are thinking of going to law school and thinking of, especially if you want to get into like corporate law or want to work for one of the big firms, grades are very important. I found out the hard way. Grades are very, very important, especially if you want to be recruited and make the big money that you hear lawyers make in these fancy offices. Then make sure you get good grades, because that's the only thing, to be honest with you, they tend to look at. Okay, so types of attorneys. There are the transactional attorneys. I think these guys, they deal more with like mergers and acquisitions, contracts. They deal with documents and make deals between companies. So like they're not in court as much as other types or litigation attorneys. They're also, like I say, they work in business to business. Family law is kind of a hybrid because they do tend to go to court more than other transactional attorneys. They deal with divorces, they deal with adoptions, child issues or child custody issues, and stuff like that. There are immigration attorneys that deal with like deportations or getting a visa for like work or for people that wanting to immigrate or want to stay here. And those tend to be, you know, more of a transactional type of attorneys, although they do sometimes go to immigration court. And then there's litigation attorneys. So I'm a litigation attorney. I do criminal litigation, but there are also civil litigation attorneys that basically, you know, they're in court suing for money, basically for damages, or if there's a breach of contract. Apple just got sued by the company that makes Fortnite because their app got taken off of the Apple the App Store. So like they're suing for money, and so those are civil litigators that are basically suing each other. Then you have people like me. We are criminal attorneys, and basically our trials involve when a charge is filed by the government against an individual, and that individual now needs to defend him or herself in court. So, you know, guys like me would, you know, basically represent them and then go to trial and make the state or the government prove their burden of whether this person committed a crime or not. So those are the type of attorneys. So purpose of a criminal defense attorney. So anybody know? I don't know if you can just say it, if you can just unmute yourself and talk about it, or ask the question. Just go ahead and do that. Anybody know what the main purpose of a criminal defense attorney is?
Defend a criminal.
Yes, defend the criminal. In terms of, do you think our primary job is to make sure a criminal or a defendant get away with their crimes?
I don't think, actually, I'm not sure.
There's a lot of misconception that actually that our primary job is to see that criminals get away with their crimes, and we get a bad rap for that. To be honest with you, that's not really our main focus. It's not about helping clients get away with crimes. I kind of see it in different categories, but first one, like you said, we're an advocate. So basically we advocate for our clients. So, you know, when a person is charged with a crime, typically a lot of times it's their first time ever in court. And they have no idea what's going to happen to them. They've never been to court, that they're scared, they're nervous, you know, their livelihood might be affected. So they need somebody who's familiar with the system, who's familiar with the players, to be their advocate. You know, make sure that, you know, they are well represented in court, and that what they have to say is heard. So we are an advocate, and we're also a protector, because we're there to make sure they're protected and that their constitutional rights are protected. So, you know, we in the United States, we are ruled, or we are our laws are based on the U.S. Constitution, and that Constitution gives each one of us certain rights that are guaranteed to us. And sometimes in their zealous advocacy, police officers or even the prosecutor might kind of stretch that out, or kind of kind of do the extremes of the system, and then we're there to basically make sure that their rights, or our clients' rights, are protected and that they are treated fairly in court. Because, you know, without the Constitution, without our guaranteed rights, our country would not be what we are right now. We're also counselors. So basically, you know, sometimes, you know, we act like therapists, even though we're not really, you know, we're not trained in specifically trained as a therapist. But sometimes, like, we have to, you know, tell them, hey, what you're doing is wrong. Like, you know, what you're you know, the path you're going on is not the right one, that we need to kind of figure out why you're on this destructive path and try to get you out of it, and try to counsel them to make better choices in life. So we're counselors in that regard as well. And then we're just an ear also. I think this might actually be sometimes one of the most significant things we do, is that sometimes they just want somebody to talk to. You know, they need to, when half of the calls I get, like, you know, I kind of tell them, hey, you don't really need an attorney, because from what they're telling me, you know, you're not ready to hire an attorney yet. But sometimes they just want to talk about what's going on in their lives, and just want to talk about, like, what their issues are. And sometimes they just need somebody to just listen and not to judge, and to kind of quote unquote be a friend, at least for the 5, 10 minutes or 30 minutes that we're talking. And sometimes that's all it takes. They just want to get things off their chest, and I find myself doing that at times as well, and that basically makes them feel better, and see that things will work out at the end. So I just put ear there because I couldn't think of a better terminology, but sometimes we're just there to listen. So that's the purpose of being a criminal defense attorney, from my perspective. Anybody have any questions so far? Okay, so let's move on. I already talked about this. There are two types of criminal defense attorneys. There's public defenders, and basically public defender works or gets paid by the county. They're basically there to represent people who are not in a position to hire a private attorney. And there are certain criteria, mostly financially, that they have to meet in order to be appointed a public defender. A lot of times, if you're in custody, even if you're rich or if you have a lot of money, if you happen to be in custody and you haven't bailed out for some reason, they will appoint you the public defender because you are guaranteed counsel. You are guaranteed an attorney when you are charged with a crime. So these public defenders, they will take those cases as well. Sometimes I get calls, or sometimes I hear from my public defender friends that their clients would ask for, I don't want a public defender, I want a real attorney, but public defenders are real attorneys. They're just as competent as we are, sometimes even more. Sometimes they have a lot more experience because they've done so many cases and they've been in the office for 30, 40 years. So, it's kind of a disservice to call them not real attorneys or that. And there's this also the stigma of public defenders just working with the DAs to try to basically move the cases along, and I find that that's not true. I find that the public defenders, for most of them anyway, are just as zealous and just as competent and just as well qualified to defend their clients as private attorneys. And then there's people like me who are in private practice, and basically we put ourselves out and to be retained for service. And we tend to have obviously a lesser of a caseload because we don't have to take every case that's being put in front of us, and we tend to be focused on less of a caseload. So if you are in a position to hire a private attorney, there's generally they can focus their attention more on your case. So those are two types of cases, or two types of attorneys, excuse me. So briefly, what's my life like, or what's my day in the life of a criminal defense attorney? And I'll just touch upon that very briefly. Basically in court every day. It's not like transactional attorneys. A lot of those guys are, basically they're on the phone, they're talking to their clients, they're meeting with companies or opposing counsel, and they're in the office a lot. Me, my morning typically starts with going to court every day. And we meet our clients, or we meet the opposing party or judges, and we deal with cases daily basis. Sometimes I'm in trial, sometimes I'm in what's called pre-trial. So my day starts with court, then go back to the office, then we have client meetings, then we administrative stuff like return phone calls, case prep, reading discovery or reading police report and stuff like that. And it's never boring. If you want to go into a legal field or want to be an attorney, but you say, I don't really want to sit in the office all day, I don't want to just deal with paper all day or contracts all day, then think about being in the criminal field, because it's definitely never boring. You will never get two cases alike, even though you might get the same type of charges or crimes. The individuals, the players that are involved are always different. The cops tend to be a different type of cops. Your clients are different. No two fact patterns are the same. So it's never boring, and that's what I like about what I do. So let's get to the nitty gritty of criminal cases in juvenile court. So basically, in criminal cases in juvenile court, there are different types of theories in criminal court, and there's what we call restorative and rehabilitative, and there's retributive. Retributive meaning like you're punishing people for their crimes. Basically, you did a bad thing, and we're going to punish you, and kind of make sure that you don't do it anymore, and to give the victims, if there are any, sense of justice. Okay. In juvenile court, it's never retributive. It's always, in theory anyway, restorative and rehabilitative, meaning that we want to restore, or we want to rehabilitate the minor, to see what happened and why it happened, and to kind of make sure that it doesn't happen again, not by punishing them per se, but using certain tools to encourage them not to do it again. Okay. So we use different terminologies in juvenile court. We don't call people defendants. We call them minors. The prosecutors, the ones that are prosecuting the cases, are not called the people. In adult court, they prosecute cases under the title "People of the State of California," that they're prosecuting under in place of the people. In juvenile court, they're called the petitioners because they file a petition to declare the minor a ward of the court, meaning that they are in need of guidance, and they're in need of some help along the way to make sure that they are going in the right direction. So there are different goals between adult courts and juvenile courts. Obviously, every criminal case starts with a police investigation, and either police are called or the 911's called, and because there's been a fight or there's been vandalism, somebody vandalized my house, somebody stole my car. We just caught these kids shoplifting in our stores. And when the cops are called, obviously they investigate. They talk to the people involved. They check the video cameras. They try to talk to the person that's accused of the crime. So they do a investigation. Once the investigation is done, then they submit that case to the prosecutor, and they do what we call a filing review. Basically, they put everything they investigated into a police report, and they submit it to the DA. And the DA reviews that, reviews any evidence that's submitted with it, and determine whether there's enough evidence to file charges. Does anybody know what the burden of proof in a criminal case is? Like, what's the requirement to proving somebody guilty of a crime? Have you ever heard that, or in TV or anything like that? Have you guys ever heard the term beyond a reasonable doubt? Yeah. Okay. I'm shaking your head. So,
I have a question actually.
Yeah.
Is it reasonable doubt or is it reasonable suspicion, or are those two the same thing?
They're not the same thing, and you've heard, and those are terms actually that I've used in criminal cases. Beyond a reasonable doubt is the burden of proof that you have to prove a case in order to prove somebody guilty. Reasonable suspicion is a standard that cops use. That's probably the most common scenario, is that when cops have a reasonable suspicion that there's been a crime committed, they have a right to search you or to arrest you. And it's another way of saying it's probable cause. And just because you have probable cause to arrest somebody doesn't mean that they're guilty of a crime. That just starts the process. And then when you go to court, the burden to prove somebody that they're guilty is beyond a reasonable doubt. And that's the highest burden in our country. Basically, there's different burdens of proof. There's a burdens of proof called more likely than not. Basically, that's you can kind of say it's like 51%. If you prove 51%, then you win, and that's reserved for like civil cases where you're talking about money. When you sue somebody for money, and because you think they breached contract or did something wrong in terms of business-wise and stuff like that, or they think you caused the accident and I was damaged, so I want to sue you, then the burden of proof is more likely than not, or preponderance of the evidence is the other way to put it. There are other basically burdens, like in family court, when you're trying to take away somebody's parental rights, like they think you're a bad parent and you want to take it away, then there's a burden of proof called clear and convincing. So that's a higher burden, but the highest burden in the land is called beyond a reasonable doubt, and that's the one you use for criminal cases, because that's correct, and that should be the way it is. Because when you're saying you're a criminal, when you're saying that you committed a crime and if you're convicted, you're branded a felon or a criminal, then you want the highest burden. You want to make sure that conviction is correct. So that's why we have that type of burden.
And then I think there are a couple of questions in the chat box.
Yeah. Not sure if I can get into chat, but
would it be easier if I just read out the questions for you?
Yeah.
Okay, let me find the first one so everyone's got in order. Hey, Pri, do you know which one's the first question?
Yeah, I found one. So someone asked, what do you find to be the most rewarding part of your job?
Most rewarding part, I think, I think I briefly mentioned this, is that I get to help individuals, people. When I was in the DA's office, at first I loved it. It was exactly what I wanted to do, but I found that these files, these cases, because there's so many of them, like we were treating them just as files and numbers and reports and just cases, and we're not really looking behind the story to see what's going on. And practically we can't really do that because there's so many cases. By the time I was done with the DA's office, I must have handled thousands of cases. So it's almost practically impossible to handle or to give each case the attention it deserves. And they deserve full attention because obviously we're dealing with people's lives and we're dealing with people's livelihoods and freedoms. But on the other side, especially in private practice, I don't have to deal with that type of massive caseload, and so I get to meet the clients. I get to meet their family. When like a minor or a teenager is my client, I get to meet their parents and kind of figure out what happened, and basically guide them through the process and make sure that they're treated fairly. Yeah, the best, or the primary goal of what I do, I find, is that we just make sure that our clients are treated fairly through the system, that they're not being railroaded, or they're not being taken advantage of, or they're not just being pushed through because they're being charged with a crime. So I find that to be the most rewarding.
Mm.
And then
the next question was, how long did it take to become a criminal attorney?
So basically you have to go to college. You get 4 years of college, 4 years university. Then you go 3 years of law school. Although there's been talks about shortening that to 2 years, but I don't think it has happened yet. So even now, I think it's 3 years. Sometimes the college I went to, they had a night program where it took 4 years because they were going part-time, because they were full-time working individuals that's going to school at night. But generally it's 3 years. And then after that, if you pass the bar, don't forget we have to take the bar exam. Basically, just like when you're as a doctor, you need to take the medical board. As an attorney, you have to pass the bar. We call it the bar. The California bar is the hardest bar in the entire nation, and that's undisputed. It's a 3-day bar. I believe they just reduced it to 2 years, and they just lowered the passing rate because the passage rate in California was just horrendous. It's like the lowest in any of the countries, any of the states. So they just lowered it to make sure it's fair for everyone. So you have to pass the bar. Only in California. So just to give you an example, in California, I believe the last bar, the passage rate was like low 40% or something like that. So it's a pretty hard exam. I've had many colleagues and friends that didn't pass the first time. And so, that's why I'm saying grad's important, studying is important, because you want to make sure that you pass it at least the first time or the first couple of times, because it gets progressively harder to pass as the more you take it. I think that's more psychological than anything else. And then, if you want, you can just hang out your own shingle and become a criminal defense attorney if you want to do that. But I recommend that you don't do that, and that you get some experience, especially if you work for the county as a DA or as a public defender, you get a bunch of experience in doing these type of cases. So that's the way I would say at least 5 years or so. For me, it took me. I went to law school, and then I worked at the DA's office for 7.5 years, almost 8 years. And then now I've been a criminal defense attorney for 13 years. So.
Oh, that's cool. And our next question is, have you ever gotten a death threat or anything scary? Like, what's the scariest part about your job?
I've never gotten a death threat, but I have had people, and rarely, most of my clients are very, very nice people. They just happen to make, poor decisions, or they just come from a difficult situation, or it was just like a spur of the moment type of thing. But I have had, I wouldn't call them death threats, but I have had people, or not people, I can just think, when you said that, just one person came in my mind actually, and that person had called me and expressed their displeasure, and he basically threatened to come to the office to have a conversation with me. And at the time I was young, I'm like, hey, I'm here, you're more than welcome. But yeah, it's very rare, and it's very rare. In fact, actually, in my opinion, and I think the statistics may prove me right, is that family law attorneys, divorce attorneys, tend to be the most dangerous type of law, because they're just dealing with people's emotions, and you're dealing with taking away kids from somebody and stuff like that. So I find that to be more dangerous than being a criminal defense attorney.
Would you want to continue with your slide, because
Sure.
we have a lot more questions? So
okay, so maybe we'll save for the end. I'll try to hurry this along so we have some time left for some Q&A at the end. So after the DA reviews it, they decide that they're going to file the case because there's enough evidence that they're confident they can prove this case beyond a reasonable doubt. They will file the case and file charges. And in juvenile court, you either get one of two things. You're either arrested, or you get a letter. More likely than not, you will get a letter at home saying, hey, we filed these charges. You need to come to court with your parents to deal with this. And that's more common. But sometimes when you're dealing with felony cases, violent cases that happened recently, or the police officers caught you in the act, or or they feel like they need to get you off the street, then they will make an arrest. And then basically, when you go to court in juvenile court, they're going there to determine whether you are going to be considered a ward of the court. Okay, that basically means that they feel like your parents are not doing the job, and that they need to kind of step in and kind of monitor you, and kind of take control of you to make sure that you are going in the right direction. So you are becoming the jurisdiction of the juvenile court. So that's the terminology used. So if you become a ward of the court, then basically they control you, and they control what happens to you. And then your first court hearing, in adult court, it's called arraignment, but in juvenile court, it's called a detention hearing. Okay, and do you know why it's called a detention hearing? Anybody? It's because they determine whether you're going to be detained or not. They're determining whether they're going to take you right from that courtroom into jail, into custody. And a lot of times, you get to go home with your parents. But a lot of times, other times, when the charges are serious, they will take you into custody and put you in the juvenile hall until your cases can be resolved and determine what happens to you. The bad thing about in juvenile court, at a detention hearing, if they decide to take you into custody, is that there's no bail in juvenile court. In adult court, in most cases, other than like murder, you can bail out. which means that if you put up enough money, or if you find a bail company that's willing to do this for you for a fee, you can bail out and come out of custody and deal with your case while you are out on bail. So you can, go home. But in juvenile court, there's no bail in juvenile cases. If they determine that you need to be taken into custody, then that's where you're going to stay until your case is over. So, that's the way it works in juvenile court. So, hopefully you guys never have to experience anything like that. What types of punishment is available or could you expect in juvenile court? A lot of times it's probation. There's a lot of times, it depends, if you're petty theft, or if you are vandalizing, you painted graffiti or something like that, or, it's a misdemeanor, you can get community service, counseling, classes, so, kind of a easier type of consequences, depending on the crime, obviously, and also your record. Obviously, if you've done this 1,000 times or hundreds of times, they got, go a lot less easier on you than if this is your first time. Okay. And then the thing about being juvenile hall or juvie cases is that you're on probation till they say you're done. In adult court, they give you a certain period, typically 3 years while you're on probation. If you're a good person for 3 years, then you're done with probation. In juvenile hall cases, you're on probation until the probation department determines that you no longer need to be on probation. Okay, or you can go to juvenile hall. Juvenile hall is basically like jail, and you can go to juvenile hall up to a year, and that could be part of your probation. You will go to school in juvenile court, and you'll do everything that's required of you in terms of. Just because you go to juvie hall doesn't mean that you don't go to classes. You go to school just like like regular, except that you're going to be in blue jumpsuit, and you have to walk one side of the hallway with your hands behind your back, and it's not fun, but so that's one of the things you can face. And ultimately, you can go to the California Youth Authority, which is like a state prison for minors. This is some place you do not want to go. It's, from what I hear, it's worse than adult state prison. And this is where you can end up going if you are a really, really bad individual and do bad things for extended period of time. Or if you are, this is your 5th petition, like you haven't learned your lesson, or your crimes get progressively worse or whatever, then they can they can send you to CYA, which is the California Authority. And again, you can go there for multiple years, and you do not want to be there. So just giving you a heads up, don't do that. Try not to go there. If you're a 16-year-old or older and you commit certain really heinous or serious crimes, you can be charged as an adult. So if let's say you committed a robbery, and robbery is considered what we call a strike offense in California. I'm not sure if you guys ever heard of that term, like three strikes cases. So it's considered a strike offense. A strike meaning that if you commit 3 of these strike offenses at different times during your life, you can be sentenced to state prison for 25 years to life. So if you commit one of these strike offenses, the DA can petition the court to grant permission to charge you as an adult. And if you're charged as an adult, you get the same type of punishment you would get as an adult. You would basically get the same type of sentences, or if you are sentenced to state prison for a long period of time, then once you become 18 and you no longer can be in CYA, and you'll be sent to state prison. So
Mr. Kim, I just wanted to throw a little reminder that we have about 10 minutes.
Oh, sorry. Okay.
No, you're good. You're good.
Okay. So let me go through 2 examples real quick.
Perfect.
So like it's an assault case. An assault case, a typical assault case is like when you get into a fight. Let's say in high school, a lot of guys tend to get into fights and whatever. So when you get into a fight, sometimes you can be charged with a crime, right? And the types of crimes that can be charged with is like simple assault or battery. If you just punch each other, push each other, and nothing really seriously happens, you can be charged with a battery. That's a misdemeanor. You can be charged with disturbing the peace for getting into like a big group fight and no one's really hurt, and you can be charged with disturbing the peace. But if somebody gets hurt, you can be charged with something like aggravated assault or battery with serious bodily injury. So a quick example, let's say you get into a fight and you don't mean to really hurt that person, but you push them, that person trips, hits his head, and then he's got he's got brain issues, or he cracked his skull open, or he's in a coma. You could be charged with battery with serious bodily injury just because you push that person and that person happens to fall, even though you basically didn't mean to hurt them. You're gonna have some serious consequences if that happens. If you get into a big fight and you are basically pounding on the guy and you're using a weapon or anything like that, you can be charged with attempted murder. And if God forbid somebody dies, you can be charged with manslaughter or murder. All this could happen because you decided to get into a fight with somebody. Okay. You can go to juvie hall. You can go to state or statewide aid for up to 7 years, depending on the charges. If you commit murder, but you are under 16 and you are tried as a juvenile, you can get a life sentence as a juvenile, and that the rule says that if the life sentence for a juvenile is up to 25 years old. So if you get a life sentence and you're a juvenile, then you can be free at 25 years old. But if you're 16 and over, you get a life sentence. You're serving life, and sometimes you can get parole, and sometimes you can't. DUIs are, obviously everybody knows DUIs. That you drink, you're under the influence, and you drive. Let me go over just what can happen to you if you get a DUI. Oops. Let me get to that. Okay, so mandatory minimum punishment for a DUI, and these are just the first-time DUI cases for juveniles. You basically have to pay a fine of approximately $2,000. You get a alcohol class, 3, 6, or 9-month alcohol class. You have to do a youthful offender program. You have to do a hospital and morgue program. That means that you have to go to the hospital, and then you visit a morgue, see dead bodies, and then you have to write a report. And then you have to do a victim impact panel put together by the Mothers Against Drunk Driving. Basically, and don't mess with Mothers Against Drunk Driving because they're a powerful organization and they will make you feel really bad about what you're doing. So that's the mandatory minimum you have to do. Okay, so which means that every time you have another DUI on top of that, you will get a lot more punishment. And don't forget, you got a 1-year license suspension. You can't get that back as a juvenile. And also, in California, there's a zero tolerance policy. So if you drink and drive and you have a 0.01% alcohol in your blood when they do a breath test, you might not be charged with a crime because it's under a certain level, but you will lose your license for a year, and you will not be able to drive. And not as my son is finding out recently, driving is a privilege, and he's it's if you get your license taken away, it's a pain in the butt. So total cost of one DUI, first time you ever get a DUI, this is the cost that your parents probably is going to have to pay. About $3,000 in fines, fees, and class and tuition. Between $2,500 to $10,000 in attorney's fees, depending on how far you get. $2,000 in probation costs. Oh, they make you pay for your own probation. Your parents pay for it. Okay, so they supervise you, but you have to pay for it. $1,500, $2,000 in higher insurance premiums. Your insurance will be jacked up high. It will be, it would be a lot more expensive. So by my calculation, it could be up to $17,000 for a single DUI that most likely your parents are going to have to fork out. All right. So if anything else, just think about how much money you're going to be wasting by getting into a DUI. This is the reason why I became a Boy Scout as a criminal defense attorney. Basically, I would see what my clients would go through, and I swear to myself I would never put myself in this situation because it is a big pain in the butt. even for minor misdemeanor cases, the amount of grief that you guys have to go through, or that my clients have to go through, is not worth getting into the trouble. Okay, what to do when you're accused of a crime? It's very simple. Just you need to tell your parents. Obviously, I've had teenagers call me and try to figure this out themselves and try to hire me themselves, and I'm like, no, you need to tell your parents. They're gonna find out anyways, because they're gonna get a letter from the court, and they won't even talk to you in court until you bring your parents. Okay, so talk to your parents, and then consult with a criminal defense attorney. Don't consult with a family law attorney. Don't consult with an immigration attorney. Don't consult with somebody that does general practice. Find a specialist, the criminal defense attorneys, and talk to them and figure out what needs to be done. Number one rule: don't say anything to the cops or anyone else about the incident. Sometimes the cops might want to question you or talk to you. Don't say anything until you talk to your parents and you talk to your attorney, because whatever you say, as you know, can be used against you, and they will be used against you. Trust me. So if you don't get it, if you don't take away anything from what I told you today, if you're ever in this situation, God forbid you're not, don't talk to the cops until you talk to your parents or your attorney. All right. So let's go to the question and answer now.
Okay, well, the next question was, what type of crime in juvie cases is the most common that you've seen?
I guess you get a lot of vandalism cases because kids love to go out and, graffiti or vandalize cars or each other's houses. I've even had criminal cases for somebody TPing somebody's house or throwing eggs at somebody's house because it causes monetary damage. So that's one. Petty theft, like shoplifting cases, I get a lot of those. And believe it or not, I get a lot of gang cases because, teenagers, gang members start out as teenagers a lot of times. So I do get a lot of serious cases dealing with gang members. So those are the type of cases that come.
I think the next question was, do you think it's more important to punish or rehabilitate criminals?
I believe in rehabilitation, but I believe there's rehabilitation to a certain point. I believe most people are able to be rehabilitated.
Mm-hmm.
So that's why we need to figure out what went wrong, like what happened to them, like what's their family background, like what went wrong, and try to address that in order to try to see if we can put them in the right path. But I also believe some people and I'm practical, and I'm not a true believer in either direction. I believe that certain people are bad, just they're evil, or they just can't be fixed. So I believe in those type of people, we need to make sure that we are protected from those people. But in most cases, I believe rehabilitation is the way to go.
I think, would you have a criminal record if you're arrested as a minor? Like, would it be on your record?
You will be on your juvenile record, and your juvenile record will be sealed once you turn 18. So let's say even if you are not convicted or your petition is not sustained, but you were arrested, that record will remain. But the good thing about juvenile cases is that once you turn 18 and you go through certain processes, or even I think after 25, automatically your records are sealed, with exceptions, obviously. So that's there for a while, but it'll get sealed.
Okay. And then I think the last question, never mind. What exactly does it mean to be on parole, and what happens during the parole period?
Yeah, you're not put on parole as a minor. That's more when you're an adult and you go to state prison. When you come out, you're on parole. I think that what the term you're looking for is probation. And when you're put on probation, basically that means that the courts are gonna take a chance on you. Say, hey, this crime you're supposed to be punished for 3 years, by 3 years in CYA, but we're gonna take a chance on you and give you probation. Which means as part of your probation terms, we want you to do this: community service, or spend some time in juvie hall, or take classes, or or just be good, whatever. And if you meet those certain conditions, we will at some point take you off probation, and you'll be done with this case. But if you violate the terms of your probation by committing another crime or not doing your classes or community services on time, then you can come back to court and we can put you in custody for the 3 years that the crime calls for. So basically they're saying, hey, we're going to give you a chance to minimize your damage here. But if you screw up, then we're going to give you everything you're supposed to get. That's what probation is.
Okay, thank you. Well, I think, oh, one more question was, can you give us an example of what to not say, like in the event we forget to not talk? Like, what's an example of?
Well, that's the reason why you should try to remember not to say anything, because when you say something, you know, it can come back and bite you, especially if you committed a crime. Let's say, you know, you're in the unfortunate situation, you made a wrong decision, you committed a crime. Then when you talk to cops, you're either going to lie or you're going to tell the truth and you're going to admit to it. Either position puts your defense attorney or your case in a more of a difficult situation before we can figure out what to do. I'm not saying that, you know, you're ultimately going to get away with it if you don't say anything, but what I'm saying is that, you know, you need to give your attorney and yourself an opportunity to evaluate what's going to happen to you. Okay, so what to say? I mean, basically, this is what I tell all my clients when they call. Hey, the cops want to talk to me about this case, and I say, well, call them back or talk to them and say politely, yeah, let me talk to an attorney, and then we'll get back to you, or my parents will get back to you. I'm not saying I'm not going to talk to you, but let me get back to you after I talking to my attorney, and then I will take over and basically determine. You know, we together will determine what's going to happen, and I'll call them and say, hey, my client won't talk to you, or we're going to reserve our rights, or oh, you know, my client has done you high, we're going to come in and give you a statement or something like that. But it's very important. If number one rule is that don't say anything until you talk to your attorney and your parents.